afternoon, everybody. My name is Amanda Morton. I'm the branch manager at the Mountain America New Daybreak location, just opened about 3 weeks ago up in the Smith Shopping Center. So pleasure to meet you all. Come and see me anytime. Thank you for coming to our estate planning lunch and learn. Leslie Hunt is actually going to be the one who is presenting to you today. Leslie's over here. So let's give you a brief introduction for Leslie. Leslie is a certified financial education instructor at Mountain America Credit Union. She is proud to be with an award-winning training team, placing 6 times in Chief Learning Officer Magazine's Learning Elite list. Leslie began her career with Mountain America in 2006. She has had many opportunities to serve in various capacities, including a collections agent, loan officer, trainer, and now a member of the financial education team. Leslie loves the privilege of educating the public, adults and children alike, on important financial matters. Leslie is married and has 3 small children. She enjoys any social event and quality time with her friends and family. So with that, we have Leslie Hunt.
All right, welcome. Did everybody get a handout? Okay, so we need a handout from here. Oh, we got some right here too. Right. Okay. Besides that, does everybody have a handout? Okay. So this is the estate planning presentation. A few years ago when I worked in Mountain America's training department, this was a 3-week class. 3-day class, sorry. This was a 3-day class. So this is an hour presentation. So we are basically giving you the very basics of estate planning, basically enough to give you enough information to start a conversation with your estate attorney. Just so you kind of get the groundwork and the basics, you know, what questions to ask. So for estate planning, these are the things that we're going to go over. These are the basics. Having a will, trust, the difference between wills and trusts, and which do you personally need. Power of attorneys, how they both benefit you both in life and in death, and then beneficiaries. One of the things that seems the most simple, but yet are one of the biggest things that throw off your estate planning. So let's start with the question. Why should you even plan your estate? Yes, absolutely. So taxes is a huge reason to plan your estate. With a lack of a will or a trust, you can be taxed up to 40% of your estate if you're not careful. So yes, so taxes is a huge one. What's another one?
Legal things as far as you don't plan for how you're going to pay money after you die. The estate will decide for you.
Exactly. In the absence of a will or a trust, your estate will be divided according to state law, and that obviously is going to will probably differ from your personal wishes. So yes, exactly. Time, yes.
Trust, everything immediately transfers.
Yeah.
So it can take a very long time.
Yeah, exactly. Especially with the trust, it's a very seamless transition. Yes. How many of you guys have ever heard this story? Mom and dad pass away, kids fight over the estate. Cause rifts in the family, right? And what parent, any parent, would ever think that any of their possessions is worth their kids' relationship with each other, right? No parent, right? So for estate planning, this is a big reason. By doing such things, you can eliminate that and not have that be your circumstance. I think we cover these. Reducing stress, expenses. Also, if you have the lack of a will or a trust or an estate, your estate will go to probate court, which we'll talk about, which could be a very lengthy process. And it is a court, and it's a legal process, so legal fees are associated with it. So the longer it's in probate court, the more expensive it is. So let's talk about wills first and foremost. So a last will and testament. A last will and testament will basically set up an executor. So who will be in charge of distributing your assets. It will state how you want your assets distributed, And it will name your beneficiary, it will name a guardian of your minor children if you have minor children. A living will. A living will is a type of will that states your medical preferences. So it'll say, like, in the event of this medical circumstance, I do or do not want these extreme measures taken. So with every will, you are going to have an executor. An executor, you need to be careful when choosing this person because it is a very large responsibility. They have to determine, if you haven't stated how you want your assets distributed, they will be the person that will determine that. And obviously, that's a big responsibility to put on someone because if other siblings or other beneficiaries don't agree with that, it's going to come back on that executor. So you want to be careful in choosing your executor. They'll file all the paperwork necessary for the probate courts, with the post offices, with the government agencies, your banks, and then they'll manage your assets until they are distributed. So like if you have a property or something, they'll take care of it or until it's able to be distributed. So with an executor, I have my parents. So like I said, I taught this class probably 10 years ago when I was teaching it on a regular basis. And I would bother my parents all the time because I would also hear, and I have heard as I've done these presentations, people's stories about what happened with their parents' estate and all the problems that went wrong with it. So I was always bugging my parents and being like, you need to set up an estate, you need to set up a will or a trust, whatever it is, you need to set it up because I don't want to have to deal with it. And my siblings, like, well, we're a family, right? No families are perfect. You know, all of your relationships are always be careful. There are certain siblings you walk on eggshells with. And my dad, finally, I was like, I got him in a car for a 3-hour drive. We were actually heading to a funeral. And I was like, okay, I don't need to know anything about your finances or anything like that, anything about your estate, but I do need to know why you won't do it. And he's like, well, so my oldest brother has a ton of great personality traits. He's a great person, but being super responsible is not one of them. And he also is like the eggshell sibling. Like, you always have to be very careful with him and how you say things. You don't want to offend him. And so my dad was like, you know, I don't really want to name him as the executor, but I don't want to offend him by not naming him as the executor. And I want to see my grandkids, so I just don't feel like it's worth it. And I was like, my eldest brother's name is Tyler. I was like, there is no way that he would want to be the executor if he knew what it was. So, like, he might be offended if he wasn't named it, but if he truly knew everything that he had to do, he wouldn't. So I found my eldest brother, and I was like, bugging mom and dad about setting up their estate, but I really don't want them to name me as the executor because, and I give him a long list of everything the executor has to do. And he's like, well, don't volunteer me for the job. He's like, but you know who would be good? Our youngest brother. So our youngest brother, very responsible. He's a financial analyst for Amazon. Everybody loves him. He's like everyone's favorite. Like we always say in our family, it's fine to have favorites as long as everyone's favorite is the same person. And that's him. That's the youngest. And so I was like, perfect. So I went to my dad, and I was like, Tyler thinks Trevor should be the executor. And my dad was like, it's a great idea. My parents were able to go on and set up their estate after that. But literally for years, as I was bothering them and they wouldn't set it up, that was their biggest hang-up. And so sometimes just knowing the information, like exactly what an executor does and having those conversations with people can eliminate just like those small hiccups. Next is a healthcare directive. This is more advanced than a living will. So a healthcare directive basically makes a contract between you and your doctor. They do have to sign a healthcare directive. This is if you have more specific wishes for your health. Next is probate court. So after you pass away and you have your will, it will go to probate court. Now, probate court will approve the validity will if it is in contest. If it's not, you don't have to approve the validity of it. They'll choose an executor if you have not. And again, that could be different than who you would have chosen. They'll total all your assets. They'll total all of your debts. They'll pay your debts from from the assets, and then whatever is left, they will distribute to your beneficiaries after they identify them. So that's probate court. And that's a lot of things to do. So do you guys think that that does take quite a bit of time, especially in a legal circumstance? Absolutely. Question back here?
Do you happen to know whether the probate judges and attorneys are paid by the state, or do they get paid by?
They get paid from your estate.
That's what I thought.
Yes. Your estate will have to pay the legal fees. Very good question. And then use the minimum amount for probate court. The very minimum, like simple, is $1,800. And it just continues to go up from there. So I got a question now. True or false? There's no way to avoid probate court. False. How do you avoid probate court? That's right, exactly. There is a way to avoid probate court, and that is with a trust. So now we're going to talk about trust. So a trust is basically a separate legal entity from you. So there are 4 parts to a trust. So the grantor is the person who sets up the trust. If I have an estate and I feel like a trust is going to benefit me. So if you don't have a very significant estate and you don't have young children that you want to name a guardian over, a will probably suit you just fine. If you have either a significant estate that either A, you want to continue on to benefit several generations, like investment properties or something like that, then you can set up a trust so it continues to live on after you. And there's numerous reasons that people set up trusts. Trusts are also going to be very specific. So you can state in a trust, my heirs or my beneficiaries get this certain amount of money every month or every year for this amount of time until the trust is depleted. You can either say, like, nobody gets anything until they each turn 32. I also have a friend in college who her grandparents had a trust, and the trust was solely set up for their heirs' educational needs. So it paid all of their grandkids tuition and fees and books. So she was a photography major. So anytime that she needed new equipment, she would go to her uncle, who was a trustee, and he would be able to pay for it or reimburse her. But that's what the trust was used for. So you can be very specific with trusts, which is one of the great reasons that trusts exist. So if I'm the person and I decide, yes, a trust is going to be in my best interest, if I set it up, I'm known as the grantor. Then there's the actual trust, and then there's the trustee. The trustee is the person who manages the trust. Now, the grantor and the trustee are typically the same person. They don't have to be. You can name a different person to manage your trust. You can even name a company. There are certain companies that manage trusts as well. And then you will have a successor trustee. So that is, in the event that you pass away, who will then become the trustee. And like I said, that can be another person or it can even be a business. And then you will have your beneficiaries. These are the people who are going to benefit from the trust. So I'm going to show you, I use this example. This is like a way we help people understand the differences between wills and trusts and which one might benefit you more. So we're going to start with Kimberly. So this is our car. Okay? Kimberly is driving. And just for the sake of this example, everything that Kimberly owns is in this car. Now, this first example is a will. So she has a will. She's driving. Unfortunately, she has a bad car accident. Kimberly dies. Dramatically. She dramatically dies. And all of her assets are spread out. Her heirs come to see everything, and everybody can see what everybody else is getting because wills are public. So what does that create? When everybody sees, like, you got this, I thought I was going to get that. Or I want this, right? Does that cause that contention that most people want to avoid? Exactly. So if you have a large estate, if you have several items of value, maybe a trust, maybe a will might not be the best. So let's do an example of a trust. Amanda, you be our passenger. So again, for this example, everything that we have, everything that Kimberly owns is in this car. Back to life. That's right. So Kimberly, she has a heart attack. the side of the road. She calls an ambulance. They take Kimberly away. The ambulance took you away.
I'm away.
And then Amanda gets out and gets in the driver's seat. See? And so now then she takes the car and drives it back on the road. Exactly. So that's kind of like a trust. So it more smoothly goes from one generation to the next, or after you pass away, it is a much more smooth transition because it is a separate legal entity from you, and that entity did not die. It continues to live on after you. Now, there's two types of trusts. The first is a revocable trust. This is a trust that can be changed at any time. You put something, tell me something you can't put in a trust.
Property.
Property. You put property in a trust. What else can you put in a trust? Money? Yeah. Personal property, assets. You can pretty much put anything in a trust. Let's say you have property in this trust, and a good good opportunity comes, so you sell that. You can take it right out of the trust. You can sell it. It is a legal process to put it in and take it out, but you have the option to do it. You can change it. Now, with an irrevocable trust, you cannot change it. Once you put something into an irrevocable trust, it then belongs to the trust and no longer to you. Why do you guys think people would set up an irrevocable trust?
If you have a problem with mental disease and you're not capable of making a decision correctly, that's the best way to do it.
Yes, that is true. So if you maybe have been diagnosed with something that you're worried going to be worried about your mental faculties in the future, you can change your revocable trust to an irrevocable trust so it can no longer be changed. Any other reasons? So when it's an irrevocable trust and it belongs to that trust, it is set up with an ITIN, so an individual tax identification number. So basically its own social security number. And so when it belongs to that trust, you no longer pay personal income taxes on the assets. So the biggest reasons that people set it up are for tax purposes.
The trust has to file a tax return every year.
Yes, the trust has to pay taxes, and it's a lot more difficult than what I just said. So if you do have questions about that revocable trust, definitely talk to your estate attorney. But that is the biggest reason people do it, is for tax purposes. Once you pass away, your trust will be converted. So if you have a revocable trust, and if you pass away, it automatically gets converted to an irrevocable trust and cannot be changed after that. When you pass away, the trustee will have to, if it hasn't already been obtained, will have to get an ITIN for that revocable trust and it'll become an irrevocable trust. Another important document you can have is a pour-over will. So when you set up a trust, it's illegal. You have to go talk to your estate attorney. We do have one. I've got his card. Oh, Brian Hoffman. I can't find it. Oh, they're in the front line. That's why I can't find them. They're in there. I can grab them. So we have an estate attorney that Mountain America recommends. We get no kickback from him. He will give, so generally when you set up a trust, it's going to be pretty expensive. You're going to be looking at least over $1,000, usually around a couple grand, depending on how intricate your estate is. It continues to go up from there. His name is Eric Larson. He is
Polson.
Polson. Eric Polson. And he, if you're a Mountain America member, he will charge you $600 to set up your estate, which is an incredible deal. And again, we get no kickback from him. Kimberly's used him. We have several members that have used him. He's just someone that we trust and we know does a very good job. So that's why we recommend him to people. If you want his card, we do have it up here. But when you go and talk to an estate attorney, they'll usually sit down and they'll ask you a bunch of questions. Okay, they'll ask you things about your estate, and then they will advise you on maybe the best way to set up your estate. He does charge $50 for each additional property that has to be put into your estate. But so again, that's a legal process. So if you've obtained something of value, let's say you buy your wife a diamond necklace for her 80th birthday, it's not in the trust, you don't want to have to go through the process of redoing your trust to put it in there. You can do a much more simple document, which is a pour-over will. So you can just basically state that you want this item to go into the trust after you pass away. Now, letter of intent. You can have a letter of intent with either a will or a trust. It's typically more with wills. If you have something very specific that you want done, you can do a letter of intent. People even do this for like their funeral arrangements. They'll state, hey, I'd like very specific things done with this, and you can do a letter of intent and have it done.
I want a bounce house.
Kimberly wants a bounce house at her funeral. She's going to be in her letter of intent. Okay, and again, it's not legally necessary, but it's something that you have. So I got another question. True or false, in Utah, you can just write a will, and that can be sufficient for the court.
A holographic will.
Holographic will, good job. Do you guys think that's true or false in Utah? It's true. Yeah.
It's got to be legal everywhere. It's legal everywhere.
Right, yeah. You can just write a will. Handwrite it, and that can be your will. Courts will accept it. But the problem with, they're called holographic wills, is that they can be very easily contested. So if they're not notarized and it's not a legal document, you open yourself up more for that. But I would say, even if you're not going to go through the process of getting notarized and going through an estate attorney, even write it down. Write it down somewhere where you even state who you want to be the legal guardian of your children, and have it give a copy to somebody who knows copy to somebody you would trust, that they would be able to file it with the probate court. So now, power of attorney. Does anyone want to explain what a power of attorney is?
One person acting on the behalf of another person.
Yes, exactly. They have one person having complete legal authority over a different person. So the most common ways I would see this when I was a loan officer is usually when a husband was deployed and a wife would call with a question on a loan. And she would be on the loan and I'd be like, I'm so sorry, I can't actually give you information on it. And she'd say, oh, no problem. I have power of attorney. So she'd fax that over to me. She could do whatever she wanted with that loan. She could sell that truck. She could refinance it because she had complete legal authority over her husband. Now, how this benefits you with estate planning is you could have two types. So you can have a financial power of attorney and a medical power of attorney. Your financial power of attorney is your power of attorney over your finances. So who you want to be in charge of making your financial decisions. And then you have another person being in charge of who legally can make your medical decisions. They can be the same person. They can be two different people. There are all sorts of different types, a durable and a springing. A durable power of attorney is, once that is signed, that power of attorney is signed, they immediately have power of attorney over you. A springing power of attorney goes only into effect in the event that something happens, like you become medically incapacitated or you're unable to make decisions as deemed by a doctor. That is when these power of attorneys come into effect. So if you don't want your kids arguing over your finances or your medical needs, you can assign one of them to make those decisions. So that's how power of attorneys benefit your estate. Now, beneficiaries. Again, one of these things, they seem pretty simple, right? You're like, oh, I know who I want to be my beneficiaries. I don't know what's going on. Sorry that that's loud. But this can throw off an estate. Anybody know how beneficiaries can throw off an entire estate if they're not done correctly? So if you name, like let's say you've got an account and you name your son as beneficiary over that bank account. And then if you're in your trust, you name your son, or your will, you name your son as a beneficiary. It contradicts each other. And then it's going to be vague. You had never named either one of them, and they're going to have to go through probate court and a legal process if they can't agree. If they can't agree who gets it, then it's a whole different process. So you need to be very careful with your beneficiaries. Also, I forgot to state this in the beginning. If you and your spouse are married, and your spouse is joint on all your accounts, when you pass away, your spouse will automatically, authority of that account will automatically transfer over to your spouse. And it's not going to have to go through probate court or anything like that. If you and your spouse have separate accounts and one of you passes away and there is no joint or beneficiary in the account, that's when it goes to probate court. And also with Utah, the standard is that it will give half to the spouse and half to the beneficiaries. So if you don't state specifically one otherwise, that's what it will default to. You also need to be careful with these certain things, insurance, retirement, because, so with your 401k, it will automatically give, let's see, make sure I get this right. It will automatically give half to your kids and half to your spouse unless you change it in writing. So careful with your 401k accounts if you haven't specified that. So now there's two types of ways to set up the beneficiary. This is also extremely important because it's going to default to one that is typically not the way that most people would like their beneficiaries set up, and you have to manually change this. So this is our first example. So this guy, Gary, he has 3 kids. So each one of his kids has kids of their own. Unfortunately, Jennifer, his youngest daughter, passes away before Gary. So then when Gary passes away, his estate is divided per capita to his remaining heirs, which means that Jennifer's kids get nothing. It's only divided among the living heirs. So this is per capita. This is what most things will default to. How most people would prefer their beneficiary set up is per stirpes. So this exact same example, Jennifer passes away before her father. Then when he passes away, his estate is divided among his living heirs and his third child's remaining heirs. That's how most people would prefer it set up. So again, it is per stirpes, but most accounts will default to per capita. So make sure that you're checking those. So we got a couple of stories. These come directly these happened with our members at Mountain America, and we have permission to use them. So this isn't actually, but this is Mary. And she was married. She was very careful with her husband. They set up each other's beneficiaries on everything. They got divorced, and then she remarried a new man. And shortly after they got married, she passed away. So her new husband went to go settle her accounts, but whose beneficiary are them? Her previous husband. Okay. Now he has the ability to contest that, but that's obviously going to be a very lengthy and expensive process, and one that could be completely avoided had she just changed the beneficiaries. Next, this is Alex. He was actually an employee of Mountain America. So Alex was an only child. He knew nothing of his parents' estate or assets, or he didn't even know where they banked. Unfortunately, both of his parents were killed in a car accident at the same time. So he was obviously grieving the loss of both of his parents, and then on top of that, had to figure out their estate. Had no idea where to start, had no idea what to do, had no idea what their wishes were. So that, if not doing it for yourself to make for tax reporting purposes or whatever, set it up for your heirs, because they're going to be grieving you. You have people that love you and are going to be dealing with that process. Don't have them take on that as well, trying to settle your estate. Okay, it's a lot of information I just gave you. Now I'm going to give you a very brief overview of taxes. Take a breath. Okay. It's not going to be, just kind of like I did with the first part of your estate planning. I'm going to give you the very basics of it, just so you're aware that they exist, the things that you're going to encounter. So with your estate, you are going to have to pay estate tax, and inheritance tax. So at state level, your estate will have to pay the estate taxes. Okay? So this one right here, your estate's going to pay it. Your inheritance tax, guess who pays that? they're going to have to pay taxes on it.
But isn't there an amount that is an exclusion for federal taxes?
For federal level, yes, so there's a gift tax, which is, I will get to that in just a second. Thank you. So yes, there is a way around it. Federal taxes, your estate again will pay the estate taxes, but then you will be responsible for the income taxes. Now, ways around these. So your gift tax. So in 2019, you won't be taxed if you give, so just you personally, you can give an individual $15,000 a year without being taxed. Now, if you're married, so me and my husband can both give Kimberly $15,000.
Yes.
So individually, yes, without being taxed. So this is something that people start to do if they have an estate and they're getting later in years. They'll start giving away things. They'll start giving away money because they're not going to have to pay those taxes, the income taxes and the estate taxes. But again, you can't just give your money away for free. There are laws around. You have to be careful. So $15,000. Oh, also, sorry, with your income taxes, if you do not have to pay these if your estate is under $5.46 million. If you're married, if your estate is under $10.86 million, you do not have to pay income taxes. I personally am hoping I have this problem. I hope I have to pay that income tax. So yeah, so you will not have to pay that if you're under that. And then gift tax is another way around giving your money away. So as you leave here today, these are the things that we want you to do. We want you to select your beneficiaries. We want you to have conversations with your family. We want you to talk, especially with your spouse. Sit down and talk to them, ask them what their wishes are. Because if you guys are setting up those healthcare directives or those living wills, make sure you understand what your spouse wants. Make sure that you and your spouse are on the same page when it comes to an executor. If you have minor children, that can be a long conversation. My husband and I did not agree who we wanted to raise our kids. So, that was a fun conversation. I won. But, just kidding. You don't want to win it here. So, next, especially with your executor, people who are going to have a large responsibility to your estate. Make sure you're talking to them. Make sure you're asking them if they will do it instead of just naming them, because again, that's a large responsibility. And then meeting with an attorney to set this up. So again, this is a legal process. We do have, like I have cards up here. A good estate attorney will sit down with you and ask you question by question to understand your estate, and they will guide you to set it up correctly. Then update your accounts and your policies. Make sure your beneficiaries are consistent. If you don't want your estate to go to probate, like if your spouse is still living, make sure that your spouse is set up as joint on those accounts or as a beneficiary. They're also known as payable on death accounts. When it comes to questions, I can't answer any personal, like if you say, hey, we're trying to set this up on our trust, but we're having this problem. I can't advise you because I am not certified. I'm not a certified financial advisor, and I am not an estate attorney. So I cannot give you advice on your personal estate, but I can answer generic questions. So, does anybody have any generic questions when it comes to estates?
My mother-in-law's had power of attorney over financial stuff, and when she died, the IRS said you are no longer the power of attorney. That died with her, and it really screwed things up. Luckily, my sister-in-law was the executrix, and we talked and all that, but what a pain in the butt.
Yes, thank you. Yeah, power of attorneys, they no longer exist after you pass away. Yes, so it's usually like when you're not able to make your own medical decisions is when they're the most beneficial. Thank you. Any other questions? Yeah.
But my attorney set up a video will. So how is that legally? How is the court going to look on that?
Yeah,
as opposed to a written will.
Yeah, so they'll view it the same way.
Okay.
There's any will can be, it's still going to be legally acceptable, but the best way to go is always going to be to have it legally done, because then it's not going to be somebody contests it, it's not normally going to change. But it is accepted in Utah. Any other questions? Okay. Again, I've got these cards up here if you guys want to. But